There are moments in history when a room meant for silence holds its breath. This was one of them. The Supreme Court of the United States, Courtroom 3, a place where the weight of the Constitution lives in every line of marble, every pause, between questions. The seats were filled. Law clerks leaned forward. Journalists hovered over their notepads. The legal elite of the nation sat shoulder to shoulder, anticipating a routine hearing. But what they got instead was a challenge to their expectations. At the center of it all stood Denzel Washington, not in a movie, not on a stage, but at the lectern, beneath the towering presence of 9 justices, dressed not as a performer, but as a lawyer, calm, focused, and immaculately composed in a tailored Navy suit. It was supposed to be symbolic, a celebrity given a rare 10-minute slot to argue as amicus in a high-profile civil forfeiture case. The murmurs had started before he even opened his mouth. A publicity stunt. He's an actor, not a lawyer. Why is he even here? And then, just 40 seconds into his opening statement, Chief Justice John Roberts made his move. With a tone sharp enough to cut, Roberts interrupted. Something highly unusual so early in an oral argument. His words were direct, personal, and unmistakably dismissive. Mr. Washington, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position. Gasps didn't echo, but the silence that followed was louder than any outcry. Justice Sotomayor shifted in her chair. Justice Kagan looked up from her notes. Even seasoned attorneys in the gallery sat a little straighter. The message was clear. This wasn't going to be a respectful academic exchange. It was a test, no, a challenge. One that questioned not just Washington's legal theory, but his right to be in that courtroom at all. Most would have faltered. Many had, under far less direct fire. But Denzel Washington didn't flinch. What followed was no longer just about the Constitution. It was about credibility, courage, and the quiet power of being more prepared than anyone expects. This was not Hollywood. This was the highest court in the land, and Denzel Washington was about to deliver the most stunning oral argument the Supreme Court had seen in decades. To the public, Denzel Washington was a celebrated actor, a master of the screen, an icon of American cinema. What almost no one knew was that for the past 5 years, while filming blockbusters and accepting awards, Denzel had been living a second life as a student of the law. Late nights on set gave way to casebooks. Days between projects were filled with lectures, research, and constitutional theory. Quietly, without fanfare or press releases, he enrolled in and completed a Juris Doctor degree from Howard University School of Law, graduating with honors. He told no one, not the media, not even his colleagues. It wasn't a stunt. It was a mission. That mission took shape when a major Supreme Court case landed on the national radar. Henderson versus Department of Justice, a constitutional challenge to the government's use of civil forfeiture, a legal process used to seize property from citizens without ever charging them with a crime. At the heart of the case, a community center in a predominantly black neighborhood, seized after a single drug transaction, happened on the sidewalk outside. No arrests, no convictions, just loss. To most legal analysts, it was business as usual, another cold battle between property law and government power. But to Denzel Washington, it was personal. He submitted an amicus brief, a friend of the court filing and a supporting the petitioners, the innocent property owners. Initially, the legal world scoffed. A movie star playing lawyer, they said. A vanity project. But behind the celebrity name was a brief that couldn't be ignored. 40 pages of originalist legal analysis, a bold reinterpretation of the Fifth Amendment's takings clause, a challenge to decades of precedent, and a theory no one, not even tenured scholars, had dared to propose. At first it was dismissed, then it was read, and when it was read, everything changed. Legal scholars who once rolled their eyes now leaned in. Professors assigned the brief in constitutional law seminars. Clerks whispered about its depth, and the Supreme Court, in a rare move, granted Denzel Washington 10 minutes of oral argument time, not because of his fame, but because of his footnotes, because of the substance, because the court, and the country realized they might be witnessing not a performance, but the emergence of a legal mind sharpened in silence and revealed in full view of the highest bench in the land. Chief Justice John Roberts wasn't known for casual remarks. His reputation had been forged over decades as a meticulous thinker, a cautious institutionalist, and when he chose to be, a master of the courtroom ambush. And now, he was staring down Denzel Washington. 40 seconds into the argument, Roberts broke protocol. He didn't wait for the point to be developed. He didn't ask a clarifying question. He struck swift and direct. "Mr. Washington," he said, with that familiar mixture of civility and steel, "I find it difficult to believe that someone from your background fully understands the constitutional implications of your position." The room froze. It wasn't the question. It was the tone, the personal edge, the suggestion, thinly veiled, that Denzel didn't belong here, that his arguments, no matter how polished, couldn't possibly be grounded in real legal understanding. Justice. Sotomayor looked away, visibly uncomfortable. Justice Kagan furrowed her brow. A few clerks glanced up from their laptops. The gallery held its breath. Denzel didn't blink. Instead, he turned a single page in the thick binder on the lectern. No hesitation, no notes, and responded with a calm so focused it silenced even the quiet doubts in the room. "Chief Justice Roberts," he said evenly, "I believe my argument is consistent with the historical understanding of the Fifth Amendment, as articulated by Justice Thomas in his concurrence in Timms versus Indiana. But perhaps we should examine the textual and historical evidence together." And just like that, he opened a worn copy of the Constitution, its margins filled with handwritten notes. Not only that, he brought original sources, court records, historical letters, excerpts from founding-era cases that most practicing attorneys couldn't name, let alone quote. He turned precisely to the page of his brief that addressed the case Roberts was referring to, the Palmyra, 1827, a decision often misunderstood even by seasoned litigators. "With respect, Chief Justice," Denzel continued, "I have not overlooked the Palmyra. In fact, on page 23 of my brief, I addressed Justice Story's opinion in detail." He paused, not for effect, but to make sure the justices were with him. While that case did permit forfeiture without criminal conviction, it was rooted in maritime law, a piracy specifically, where the vessel itself was treated as the offender. A legal fiction that made sense where personal jurisdiction was impossible. His voice was steady, his pacing deliberate. No stammering, no showmanship, but Justice Story never intended that exception to swallow the rule, and certainly not to justify the seizure of real property from innocent Americans, fully within the court's jurisdiction. He looked up, not defiant, not smug, just confident, clear. "In fact, I've traced every civil forfeiture case decided by this court between 1789 and 1850. All 27. Every single one involved maritime seizures, customs violations, or piracy. Not one approved the type of land-based seizure we see in Henderson." Silence. The courtroom, full of attorneys, clerks, justices, understood what had just happened. Roberts had tried to set a trap, and Denzel Washington walked through it by building a bridge of facts right over it. It was no longer a question of whether he belonged. It was now a question of just how far this argument was going to go. What began as a courtroom curiosity was fast becoming something else entirely. Denzel Washington hadn't just parried Chief Justice Roberts' challenge, he had turned the tide of the room. The atmosphere, once tinged with skepticism and condescension, now buzzed with quiet recognition. Even the justices felt it. Justice Samuel Alito, a reliable voice in favor of law enforcement powers, leaned forward, breaking the silence. "That's an interesting historical observation, Mr. Washington," he said, his voice measured. "But how do you account for more recent precedents? In Brilliance versus Michigan, this court upheld the forfeiture of a vehicle from an innocent owner. A trap of a different kind. Brilliance was controversial, but it remained settled law. Few dared to challenge it in open court. But Denzel didn't flinch. "Justice Alito," he said calmly, "I believe Brilliance was wrongly decided." A ripple of surprise ran through the chamber. To directly criticize Supreme Court precedent, in front of. The justices who had upheld it was a bold move. Reckless, if you were unprepared. But Denzel wasn't unprepared. And I'm not alone in that belief, he added. Justice Thomas, joined by Justice Ginsburg, dissented forcefully. Bennis created a constitutional tension this case allows the court to resolve. He turned another page. Since Bennis, this court decided Austin v. United States, recognizing that civil forfeiture is subject to the excessive fines clause, and Timms v. Indiana, incorporating that protection against the states. Together, these decisions affirm that civil forfeiture is quasi-criminal and must respect due process and proportionality. Now, the room wasn't just listening, it was learning. Justice Clarence Thomas, silent for much of the argument, studied Washington carefully. His pen, for once, moved across the page. Justice Brett Kavanaugh entered the exchange. Your historical argument is compelling, Mr. Washington. But there's a practical concern. Civil forfeiture is a major law enforcement tool. Are you suggesting we eliminate it entirely? Another pivot point. The kind of question designed to expose idealism without answers. Denzel answered without missing a beat. Not at all, Justice Kavanaugh. I'm suggesting that we return it to its original boundaries. He held the court's gaze as he laid it out. Civil forfeiture remains appropriate in traditional contexts, maritime law, customs violations, or when jurisdiction over a property owner is impossible to establish. But when the government can bring criminal charges and chooses not to, yet still seizes property from citizens without process or proof, that is when the Constitution demands higher scrutiny. Now, even Roberts had stopped watching with skepticism. He was leaning in, not to trap, but to understand. And he wasn't alone. The gallery, the clerks, the attorneys, the law professors in the back rows were no longer spectators. They were witnesses, witnesses to something rare. A man who had spent decades delivering lines written by others was now crafting a legal narrative of his own. Every word, every citation, every note of controlled conviction. This wasn't performance. This was command. By now, the shift in the courtroom was undeniable. The man once dismissed as a performer had become the most commanding voice in the room. The robe of celebrity had fallen away, and what remained was unmistakable. A scholar, a strategist, and a legal mind shaped not by fame, but by disciplined thought and deep research. Chief Justice Roberts, visibly recalibrating, attempted to regain control of the narrative. Mr. Washington, he said carefully, your brief cites several obscure founding-era cases from state courts that most scholars haven't discussed. How can we be confident these represent mainstream constitutional understanding rather than fringe opinions? It was a familiar Roberts tactic. Test the foundation, expose the weak brick, discredit the case by questioning its historical grounding. But, again, Washington was ready. I'm glad you asked about those cases, Chief Justice, he said, and there was no condescension in his tone, only clarity. Far from being outliers, they reflect a consistent pattern across jurisdictions in the early republic. And then, from memory, he listed them. 8 state Supreme Court decisions. Their facts, their holdings, their alignment with one another and with federal precedent. No notes, no hesitation. Justice Elena Kagan, a noted constitutional scholar herself, broke in, visibly impressed. Mr. Washington, your historical research is remarkable. Did you work with a team of legal historians to prepare this argument? For the first time, Denzel allowed a flicker of pride to show. No, Justice Kagan, I certainly studied the work of leading scholars. But the primary research, tracing cases through archives, reading original opinions, letters, drafts, I conducted myself at the Library of Congress during my studies at Howard Law and in the years since graduation. A quiet murmur swept the room. For many in the chamber, this was the moment they learned something that changed everything. This wasn't a celebrity's hobby. This was a jurist's craft. Even Roberts, who had earlier questioned his right to speak, looked momentarily. Unsteady Justice Sotomayor saw the moment and moved the discussion forward. Mr. Washington, returning to Henderson, how would your historical framework apply to the seizure of the community center? Without missing a beat, Denzel turned toward her. Justice Sotomayor, he said, under the original understanding of the Fifth Amendment, the government's action fails on multiple grounds. First, the connection to criminal activity is tenuous at best, a single drug transaction on a sidewalk by a third party. Second, the owners had no knowledge of the act. Third, the forfeiture is grossly disproportionate to any harm caused. He paused. The air hung still. But most fundamentally, this seizure violates the public use requirement of the Fifth Amendment. When the government takes property and uses the proceeds for general revenue, not to redress a specific harm, it no longer serves a constitutionally valid public purpose. His voice was calm, certain, unapologetically constitutional. At the bench, time had expired, but no one interrupted him, not the chief, not the clerk, not even the clock. Instead, officers at the side of the room subtly extended his time, a quiet but unmistakable signal. Keep going. We're not done here. What had begun as a spectacle had become a symposium, and the man once assumed to be reading lines was now writing them into the constitutional record. As Denzel Washington concluded his argument, the courtroom did not return to routine. There was no gavel, no sharp cutoff, no perfunctory "your time has expired." Instead, there was silence, an extended, thoughtful silence, the kind that only follows something rare, something exceptional. Several justices continued taking notes. Others leaned back in their chairs, digesting what had just occurred. It wasn't just the content of the argument that stunned the room. It was the delivery, the preparation, the undeniable force of clarity. Then Chief Justice Roberts spoke, his tone now transformed. "Thank you, Mr. Washington. Your argument has been exceptionally informative." A simple statement. But in this room, from this man, it carried weight. It was an acknowledgement, not just of the legal substance, but of the transformation that had taken place in real time before the eyes of the court and the nation. As Washington gathered his notes and stepped back from the lectern, the government's attorney rose to speak. But something had shifted. The room no longer belonged to the government, not intellectually, not morally, not strategically. The power dynamic had reversed. This was no longer a hearing about a contested piece of property in Philadelphia. It was now a test of constitutional principle, of who the law serves, and how faithfully the court would guard the rights it was built to protect. And outside the courtroom, the shockwaves were immediate. Within hours, transcripts of the argument were circulating through law schools and legal blogs. Professors assigned the brief to students. Scholars from across the ideological spectrum, liberal, conservative, originalist, progressive, praised the precision of the reasoning. CNN's lead legal analyst put it bluntly, "I've covered the Supreme Court for over 20 years. I've never seen anything like this. Denzel Washington didn't just make a good argument, he changed the trajectory of the case." Social media followed fast. Hashtags like "Was Legal Scholar Denzel," "What Denzel Schools the Chief," and "Constitutional Clarity" began trending across platforms. Clips of Denzel citing obscure Madison letters, quoting 18th century state court cases from memory, unpacking the Palmyra like a professor of admiralty law. Millions watched. Millions were stunned. But most important of all, millions were inspired. And then came the ruling. 6 weeks after the oral argument, the Supreme Court issued its opinion in Henderson v. Department of Justice. In a 7-2 decision, the court ruled for the petitioners, significantly restricting the federal government's civil forfeiture powers. The author of the majority opinion, Chief Justice John Roberts. A gesture not just of jurisprudence, but of grace. A recognition that wisdom can come from unexpected places, and that humility, too, has its place on the bench. In a move without precedent, the opinion quoted Denzel's oral argument 4 separate times, including his proposed 3-part test, which the court largely adopted. A footnote offered something even more rare. The court commends counsel for amicus curiae for exceptionally thorough historical research that illuminated founding-era understandings of property protections. Justice Thomas authored a concurring opinion going further, calling for a complete re-examination of civil forfeiture under originalist doctrine. Justice Sotomayor's concurrence focused on disproportionate harm to minority communities, explicitly referencing the statistics Denzel had presented during argument. And at the end of the majority opinion, Roberts added a final personal reflection. This case reminds us that legal wisdom can come from unexpected sources, and that our system of justice is strengthened when diverse voices and perspectives are fully heard. The words were his, but the weight behind them belonged to Denzel. The Supreme Court's decision in Henderson versus Department of Justice sent shockwaves through the legal world. But what followed was more than policy change. It was a cultural and intellectual reckoning. Within weeks, states across the country began reforming their civil forfeiture statutes to comply with the new constitutional framework. Property worth millions, once taken from citizens without trial, without charges, without warning, was returned to community centers, small businesses, and families. Law enforcement agencies, once aggressive in pursuit of low-bar seizures, began to shift focus, from broad net to narrow target, from profit to principle, from power to accountability. And at the center of it all, the man who once stood at a lectern as a courtroom outsider was now seen as a legal force. For Denzel Washington, the case wasn't a career shift. It was a mission realized. He continued acting. He continued directing. But now he added something new. The Washington Justice Initiative, a nonprofit organization dedicated to providing legal representation for communities affected by civil forfeiture and broader property rights issues. Law schools invited him to guest lecture on constitutional history, not because of who he was, but because of what he had done. At Harvard, Yale, Georgetown, Stanford, students read his brief as part of the curriculum. They quoted his oral argument. They studied the precision of his originalist method, the clarity of his constitutional reasoning, and then, 6 months after the decision, an extraordinary event took place. Denzel Washington and Chief Justice John Roberts appeared together, on stage at Georgetown Law School, at a forum on civic education and judicial humility. The energy in the room was electric, not from conflict, but from mutual respect. They spoke openly, candidly, even with moments of quiet humor about their courtroom encounter. And then, Roberts said something that would be quoted in lecture halls and editorial pages for years to come. Mr. Washington taught me something that day. Never to confuse celebrity with capability. Never to assume that unconventional paths to legal knowledge are less valid than traditional ones. His argument in Henderson will be studied by law students for generations. Denzel, in turn, responded with the grace that had defined his entire journey. The beauty of our legal system, when it works as it should, is that arguments rise or fall on their merit, not on the identity of those who make them. I'm grateful that the court was willing to engage seriously with the constitutional questions in Henderson, no matter how unexpected the messenger may have seemed. The moment, humble, direct, and deeply human, was shared across social media, included in orientation materials at top law schools, and cited by advocates of reform nationwide. It became a symbol that brilliance can emerge from anywhere, that thorough preparation can upend prejudice, that a courtroom, when honest, is still the fairest stage in America, and most of all, that the law at its best listens, not just to power, not just to tradition, but to truth, wherever it comes from. If you found this story inspiring, a story of justice, humility, and unexpected excellence, subscribe to our channel for more. And remember, never underestimate someone just because they don't fit your expectation. In the end, it might be their voice that redefines what justice truly means.